Welcome back to the LNF Rosa Supreme Court, but more course. And we do have somewhat of an erratic schedule, but we're really happy that you're enjoying and joining us today. Our next session will be on Monday, November 14th, when Merritt McAllister will address gun rights and the Second Amendment. So today we're honored to have Professor John Mills, who is Dean Emeritus, Professor of Law, and co-director of the Center for Government Responsibility at UF's Levin College of Law. He's also counsel to Boies, Schiller, and Flexner, LLP. Professor Mills is former dean of the UF Levin College of Law from 1999 to 2003, and former Speaker of the Florida House of Representatives from 1987 to 1988. He served as a member of the 1997 to 1998 Florida Constitution Revision Commission. He's a globally recognized expert in privacy and cybersecurity issues. His CV is too full of achievements for me to summarize here, but I did note that he's spoken to ILR several times, particularly starting in about 2007 when he spoke to us about privacy issues. And he emphasized to me that his mother was one of the first residents of Okemuk and absolutely loved being here. Today, he's going to talk to us about the future of fundamental rights. Professor Mills?
Thank you very much for that kind introduction. Yes, my connection with Okemuk runs extremely deep. Helped my mother move in here very early on. Marguerite Mills, some may remember. There's another Marguerite Mills in our family now, my daughter. I have two daughters. I have a t-shirt that says, "You can't scare me, I have two daughters." And I've loved Okemuk since then. I love to come back and do this and share the opportunity to have a conversation. And we will do this as a conversation. The Supreme Court is obviously become a controversial area. I this morning taught a constitutional law class to law students, and we were talking about abortion, the Dobbs case, and the future of fundamental rights, which is, I'd like to talk to you about the future of fundamental rights because there are some questions. Now, what's a fundamental right? Well, we as citizens of the United States make some assumptions about the rights we have. Let's see if this. We're getting in the mood now. All right. So fundamental rights, things like freedom of speech, due process. There are various issues that are explicitly mentioned in the Bill of Rights. Right to be free from search and seizure. Those are mentioned specifically in the Bill of Rights, but that's not our full list of fundamental rights. So we've come to expect some other rights that include the right to refuse medical treatment. Now, you don't find that anywhere in the Constitution. So there are a series of rights that we have come to expect to be constitutionally protected. And constitutionally protected is fundamental, which means if government is going to tell us to do something different, they have to show a compelling interest. So keep in mind, many of these things were controlled by government at one time, maybe all of them. So The right to refuse medical treatment, you and we have a constitutional right to refuse medical treatment. We do not have a constitutional right to physician-assisted suicide. The court acknowledges that states can create a process to do that. Some states have. Marriage. Marriage is considered a fundamental right. Now, the question is, why? So in their analysis of marriage, they looked at the earliest traditions of the United States. And so marriage helps what? Preserve the family, preserve the community. So therefore, the right to marry can't be freely denied by government. We have a couple of cases, though, that have come up. Loving versus Virginia, which of course there was a movie called Loving about interracial marriage. Well, interracial marriage was illegal. And until the 60s, this is not ancient history. The justification for prohibiting interracial marriage that was argued by the state of Virginia is a little chilling. So that this was a challenge to the purity of the white race, and then proceeded to define what, quote, the colored race was, and argued that it didn't deny equal protection because it treated whites and blacks equally. Neither one could marry the other. Good equal protection argument, right? Well, court got around that. So marriage, why would marriage, if the issue is marriage and it's a fundamental right, why would you deny it to a person based on race? So Loving versus Virginia said you could not do that. So the next question is Obergefell, the case of same-sex marriage. Now keep in mind the analysis, and we're going to get to the Dobbs case, which is the recent Supreme Court case dealing with abortion. And just a quick preview of an analysis of that. It said that abortion is not a right because abortion was not fundamental to ordered liberty at the time of the Constitution or at the time of the passage of the Civil Rights Amendment. So it's a historical analysis. We come back to this because if you do a historical analysis on each of these rights, what do you come up with? So is the historical analysis of Obergefell, which is same-sex marriage, is it a right to marry or is it a right for same-sex marriage? So if you do a deep historical analysis, there's not a deep historic right to same-sex marriage, but there's a deep historic right to marriage. So should you argue that it really is a classification issue and that it's unfair to classify someone because they are an LGBTQ differently than someone who is not? So that's the argument in Obergefell, and they overturned the prohibition on same-sex marriage. So that is a fundamental right. This is all leading up to where we are now. Personal intimate conduct, Lawrence versus Texas, it's criminal law against homosexual activity. So the analysis was intimate personal sexual activity is a matter of personal autonomy, and government should not be defining it. So that's what prevailed. Again, think of defining the issue. The issue is personal autonomy or homosexual relations. And to choose to define it in a way that preserves it, it's personal autonomy and liberty. No matter what, that personal, intimate sexual conduct was a right of personal autonomy. It didn't matter who you were. But would that survive the test of long history? Right to contraceptives. That's not that old either. 1965. So access to contraceptives was determined to be part and parcel of family marriage with the initial case, personal autonomy, etc. So laws that found the sale and receipt of contraceptives criminal were overturned. Subsequent cases expanded that to individuals who are not married. Now, in 1965, can there be a deep history since 1860 and 1790 about contraceptives one way or the other? Not in the 1700s. Abortion. Roe versus Wade. The Roe court found that the right to abortion was an intimate personal autonomy decision, and that the state could not absolutely restrict it, but it could restrict after trimester. So there was, even though this was for a woman a fundamental right, the state had an interest in, quote, potential life past a certain stage. The dissent said, this is none of our business. This is a terrible decision. It's worth reading the dissent because the dissent has now become the majority. That the state has that the United States Supreme Court has no right to interpret what abortion should be lawful and what shouldn't, but the states can. The Casey case came a few years later and affirmed, changed the standard somewhat, saying you can't place an undue burden on an individual's right. So you can't do things like require the procedure room to have full emergency facilities, or you can't require there to be certain doctors, there are impairments. And those were described as undue burdens. Dobbs, we're going to treat Dobbs in a minute, but that's the case that just happened, where the dissent in Roe became the majority. So as a quick summary that we'll get back to, the holding in Dobbs is that there is no constitutional right protected to have an abortion, and that it's completely up to the states. So the state could do anything. In this case, the case before the court was a 15-week limit from Mississippi. They could have just upheld it and said 15 weeks was lawful, but the majority of the court went on to say, we are going to take this opportunity to say Roe versus Wade is unconstitutional and overrule it. And those of us who practice law or know law, or even who have read casually, there are things like stare decisis and precedent. So the question was Roe versus Wade precedent? And yeah, yes, it was. And the court in Dobbs said, we choose to overturn it directly. So it was unambiguous that they said Roe was wrongly decided. I mentioned these other two. You're going to get some more on right to bear arms. I mentioned this here for this reason. In this same session of the Supreme Court, they decided these two cases. Dobbs and New York State Rifle. In Dobbs, they decided there's no constitutional right to an abortion. In New York State Rifle, they affirmed that there was a constitutional right to bear arms. And the interesting analogy is, that means all of those things that have been viewed as impairments and undue burdens can't be done related to abortion. Or, I'm sorry, can be done related to abortion. And when you look at the restrictions under New York gun and other government, there's an analogy. There are waiting periods. There are things to delay or burden the purchase of firearms. So the court has said, sorry, you can't burden the purchase of firearms. You can burden abortion. Interesting analogy. And the court will say, and did say, well, firearms is based on an explicit constitutional provision, Article 2. So there's a textual basis. And in abortion, they say there's no textual basis. And there is no textual basis for abortion. The question is, one of the questions specifically in all of these rights, like marriage, refusing medical treatment, personal intimate conduct, contraception, abortion, rights of parents to raise children, none of those are in the Constitution. But they have been interpreted to be fundamental rights, and they're things that we have come to think of as part of our constitutional structure. We raised today the issue of what has Dobbs done to that? Is there a risk for all of these in the future? Loving versus Virginia again. The language is interesting on marriage. Marriage is one of the basic civil rights of man, fundamental to our very existence and survival. Under the Constitution, the freedom to marry or not to marry a person of another race resides with the individual, cannot be infringed by the state. So that's clearly defining a constitutional right. It's not found in the Constitution. I mean, there's nowhere it says you have a right to marry. Similar reasoning in Obergefell. Court felt the right to marry is a fundamental liberty. It's inherent in the concept of individual autonomy. Protects most intimate association. Safeguards children and families. Historically been recognized as a keystone of social order. Topic being marriage. Question being, if you begin to change the analysis and say, not marriage, but gay marriage, does gay marriage beat all of those factors? So the court reasons that the exclusion of same-sex couples from the right to marry violates due process and equal protection. Again, originally in Roe, recognized as a fundamental right. Last point is interesting here. There is a time when the state's interest does become compelling, that it overrides considerations of maternal choice. So that says you can regulate at a certain time. Planned Parenthood versus Casey. changes the standard slightly by saying it's an undue burden. These are examples of undue burdens. 24 hours is not an undue burden. Licensed physician is not an undue burden. What was defined as partial birth, not an undue burden. State is not obligated to subsidize facilities. And Dobbs. So now the question is whether the right to obtain an abortion is rooted in the nation's history and tradition. And is it an essential component of ordered history? And so the court's answer is no. Now, almost all states had criminalized abortion, so they're using the history of specifically abortion-related cases and not asking the question in the context of bodily autonomy. Now, I just mentioned New York rifle as comparison. Is a fundamental right. You can't restrict it. If you're in the protected group, you're entitled to obtain a firearm. The state's not entitled to restrict it. Now, the question that I really want to discuss with you is what happens after Dobbs? The dissent raised the question is, well, what about the rights to contraception, same-sex marriage, interracial marriage? What about all of them? That if you've now changed the test, and the focal point of the test was abortion, fundamental to ordered liberty, not the question of familial rights or autonomy. Can you answer that question differently for other rights? Justice Thomas made himself clear. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents. Griswold, Lawrence, Obergefell, because any substantive due process decision is demonstrably erroneous. So here is the question. Justice Alito, who wrote for the majority, said, let me be clear, this decision is only about abortion. Those other decisions are different. Don't worry about it. The dissent says, worry about it. The dissent says, if you just apply the same test you're applying to abortion on a narrow basis on these other issues, why wouldn't you overturn them? And, well, Justice Thomas said you should. It's interesting, the other members, Kavanaugh said, don't worry. It's very interesting, the Chief Justice did not want to overrule Roe versus Wade, but wanted to uphold the Mississippi case. He didn't want to overrule Roe versus Wade partially for this reason, because it makes suspect all these fundamental rights. And it's clear that Thomas is perfectly willing to reconsider all of those decisions. Thus, the importance of the majority that actually overturned Roe versus Wade would seem to place in question some of these other fundamental rights. and that is something which Thomas actually explicitly articulates. The others say no. So yeah, I want to end on that and start discussion because there are these series of constitutional rights which we've now assumed are settled. Well, many people assume that abortion was settled. And it is interesting, particularly to look at the Chief Justice, who's not a raving liberal, saying that it was really a mistake to overrule Roe. The logic of the majority is this is not a constitutional right. It is too difficult for us to decide. We shouldn't decide it on a constitutional basis. Each state should decide it in the democratic process. Now, philosophically, one thing we should discuss the courts and the Constitution are there to protect us from the majority. So if something is a constitutional right, you shouldn't have to vote on it. So the question is, what is a majority or what is a constitutional right? If it is a constitutional right, it shouldn't be up for a vote. I mean, we have changed. The other case that I discussed today was the Dred Scott case. Now, the Dred Scott case was one of the worst cases in American history. It's found that a slave was property, was not a person, could not be a citizen, and that had to be returned to their owner. That was precedent. So, well, it was overturned by the 14th Amendment in a whole series of cases. But if there are individual rights that are important enough that have to protect the minority, courts have to do that. So that's the real question. Dobbs has placed into question whether these other issues of fundamental rights should be returned to the states. Or is Dobbs different? So let's get in a conversation.
Entertaining questions from Potomac as well as online. Please raise your hand electronically.
It's Keith Berg. And I'm imagining a situation where I'm referring to the case about marriage, the right to marriage, and the issue that you brought up about the gay or lesbian community, and the decision that it wasn't, that distinction wasn't made in the original one. So I'm imagining a situation where I come from a Scandinavian background, where maybe a Swede couldn't marry a Norwegian. I mean, that's not specified in the Constitution. Or maybe if I have a tall person can't marry a short person, or someone who has a hearing problem can't marry someone who hears perfectly well, or someone who now forgets people's names no longer can marry someone who has perfectly good memory, and so on and so forth. So I don't know how you could make the distinction about one particular subset of people and not have to allow it to be made for anybody, for any other situation.
So I think that is, so you're suggesting that they're finding that it's a right in a larger sense is the right finding. Yeah, and that, so marriage, and it's a very interesting opinion to read because it espouses all the advantages of marriage to the individuals and to society, and then says, well, why are we denying it? Yeah.
John, thank you for bringing this very important issue to everyone's attention. I'm wondering is there any law that the U.S. Congress could pass that would clarify this so that we do have equal rights across the board?
So Congress, as a matter of fact, Kavanaugh specifically suggests that this is within the power of political bodies, meaning either the states or Congress. So could Congress pass something? Presumably, yes. That would, now the question is, could they pass something authorizing abortion? Could they pass something prohibiting abortion? According to this court, it's none of their business. So they recognize in the majority opinion that they expected for some states to authorize abortion. They have, and they expected for other states to restrict it. And that because their position was there's not a protectable constitutional right, whatever you do is going to be fine. Now, let me just, the interesting thing that Robert said is you keep saying as a majority that you don't want to make any decision, that for us to make a decision as to, quote, when life starts or when the right begins, we shouldn't do that. Elected officials should do that. Well, by affirming this Mississippi case, they did that. And Robert's pointed that out. They affirmed a 15-week period. Yes, sir.
Yeah, Larry Lowenthal. The original decision, Roe v. Wade, was pinned on a assumed right to privacy, which is not in the Constitution. Justice Ginsburg thought it'd be far better to pin it on the Equal Protection Clause, which certainly is in the Constitution, and much more easy to defend. What do you think?
That's really an excellent insight, because most of the arguments here are constructed around it's not in the Constitution. And therefore, that's why I'm throwing the comparison up of New York Rifle. The New York Rifle, the rights protected there are interpreted to be in the Constitution. It's in the Second Amendment. So the Second Amendment has rights related to guns. And right, the word privacy is nowhere in the Constitution. So the right to privacy was in that case derived from, they said, the First, Fourth, Fifth, and Ninth Amendments and a penumbra, and they said that was the same thing in Griswold. Now, of course, the dissent said that's ridiculous, and then the Dobbs majority says that's ridiculous. There's nowhere in the Constitution to protect it. The equal protection is in the Constitution. The other word that's in the Constitution is liberty. So some of these interests, when they're defined as a liberty interest, that is the freedom to do something, there's a basis. And the equal protection makes perfect sense in same-sex marriage, in interracial marriage. I mean, those are strong arguments. And there are people that suggest exactly as you do, that would be a safer argument than basing it in due process, because due process, the way they've interpreted, has to have some basis in history. But parenthetically, is it interracial marriage that has a basis in history, or is it marriage? And then if you have marriage, then you have equal protection, and you got it. Yes, sir.
you've pretty well covered the concept of constitutional and judicial rights. Would you compare the concept of God-given rights with these?
The way the judiciary occasionally recognizes things as natural law, that there are natural law rights that exist and that the Constitution merely recognizes them and protects them. So that there is language in some of these cases that suggests that we're just recognizing the existence of something that's, if we are supposed to be protecting dignity and individuality, we have a constitutional basis on which to do that, but the logical and historical and moral basis is something else. But yes, they're always going to find something in the Constitution. And there's something, an amendment that most people don't talk about, and most law professors don't talk about, is the Ninth Amendment. The Ninth Amendment, if you look it up, is really short. And it was, I believe it was Hamilton, or it basically says, any rights not explicitly preserved here are reserved to the people. So that means there are more protections than are simply enumerated. So that's why the Ninth Amendment was cited on issues like abortion, contraception, et cetera, be saying, I don't have to find the actual text. There are other rights that can be reserved to me, and how do I go about figuring those out? Maybe moral, historical basis for those rights, but the Ninth Amendment says there's something there beyond just the words.
Go ahead, Don.
Sean, Don McLaughlin here.
Hey,
I have two general questions. If you look at the Supreme Court and its attitude towards states' rights over the years, has its posture changed in that regard? The second question is, I think you used the phrase ordered liberty? Ordered liberty, or something to that effect?
I'm sorry,
No? Okay. I don't
liberties?
know. Anyway,
Maybe I can't hear.
no.
I'm
What
one of
about
those
the,
people that won't be able to get married.
what about the states' rights issue then?
States' rights issue is, well, there's a clear context for it in an arc of history. There's the basis in states' rights is clear. The 10th Amendment says rights are reserved to the states. The basis of the Constitution was approved by the states. We have a federal system that recognizes dual sovereignty, that the states can be sovereign and the federal government is sovereign. So there are rights that are reserved to the states. The way the federal Constitution is written is if you, Congress, are doing something, you have to find a source of authority to do it, whether it's the Commerce Clause or some other clause. States have a general police power, so they can do it unless they're specifically prohibited, or if you violate a United States constitutional provision. So the state's power is extremely broad, and it's been recognized as such. And the Dobbs case recognizes states' rights over and over again. There are a number of other cases that would indicate what is articulated as judicial restraint, which is to say we are 9 unelected people making a decision for everybody in the country. Shouldn't it be made by elected officials at the state level? That's the way Dobbs is articulated. So yes, the states' rights has been on an upward arc, but it's also why through New York Rifle up there, that is the reverse. Because you would say, well, doesn't New York have a better idea about what gun rights should be, and shouldn't gun rights in New York be able to be described differently than they are in Montana, et cetera? And the answer to that is no, because you have an individual constitutional right.
Thank you. Shirley on Zoom, go ahead.
Hello, John. Thank you so much for helping us to talk through and think through this. I really need some help in changing my conception of what my expectation of the Supreme Court might be. I always thought that they were non-political and they were supposed to try to determine what was the best thing relative to the Constitution and protecting us and being reasonable. Now it seems that it's so political, just being railroaded by the Supreme Court judges' political view on how the country and people should be. What is the possible thinking on this? Is it remediable? There's no ethics group. There's nothing to control this kind of wayward thinking as far as what the supposed thinking of the non-political part of these justices should be. Help me.
Well, I actually had a question that was analogous to that in a class of students this morning. And I said, I am not completely cynical. I think that if you look historically, you can't track directly the source of an appointment to ultimate decisions. And there's some remarkable differences. For example, Brown versus Board of Education, which dealt with school segregation, was a 9-0 opinion. And the Chief Justice was a Republican who was thought to be a segregationist. So I guess, to be optimistic, people change. Another historic footnote is in 1935, the court was giving Roosevelt a very difficult time. Roosevelt's New Deal required Congress to pass various regulatory structures, and they were using the Commerce Clause to impose consumer protections, child safety laws, other laws like that. And the Supreme Court was striking them all down. If you remember the point in history, there was some suggestion that Roosevelt wanted to, quote, pack the court. And there was a change in direction of the court about 1937. And some people said, well, gee, maybe Roosevelt sort of persuaded somebody. They said a switch of 2 votes changed in National Labor Relations Board versus Jones. All of a sudden started approving the legislation that Roosevelt had. So I don't think there is an answer to this. Appointments matter. If you look at the broad spectrum of cases, we will have to track them, but these cases, the Dobbs case is troubling if you look forward. So I'm not of much comfort.
What is the option of controlling it?
Well, court packing is apparently not a real option. There are political solutions, and that's where you are. I mean, you have to hope or work for changes if you don't agree with the viewpoints of those that are appointed. For these other cases like same-sex marriage, etc., in reading the other opinions, I don't think they're going to overturn them. But that's just me. I mean, there are certainly people, even on the court, that would like to. And when they draw the distinction they try to define the abortion issue as explicit, limited, and sui generis in and of itself, because it's not like same-sex marriage, because it involves the definition of volition in one life and the potential existence of another life. And then you have to define when you think that exists. And so they say, therefore, abortion is different than same-sex marriage, interracial marriage, contraception, and the others. Yeah.
Hold on. Randy, go ahead. Right at your mouth. Right. Randy, hold it just like this.
Mike was coming.
Okay, Randy Fabal, and I got kind of two questions. One is, okay, two questions. One is the kind of tension between the Ninth and 10th Amendments as to which rights are the people's and which are the states. And they're just tending more towards what rights are the states' rights that the majority may want to impose on a large minority or a small minority. And, you know, they tend to stay away from trying to do that analysis because there's no good basis for it pretty much anywhere in the case law. And they'd really be creating new law that hasn't been explored, you know.
Yeah, to say the 10th Amendment is cited all the time. The 10th Amendment has been cited all the time, reserving states' rights. The 9th Amendment is very rarely cited. There is not much interpretation of the 9th Amendment.
That's what I was saying. That's what they keep going to. And I guess the second thing is, what about a lot of this, well, it's not a lot, I know it's Texas and maybe one other state, that are taking things that they want to impose, that they can't, and turning it into the personal action that you have a right against another person if this person does something that might be illegal in our state, but is legal across the border. And I think that's just,
Yeah, you're talking about declaring it illegal to maybe help someone cross the border to seek an abortion. Yeah, that'll be challenged. And so there are things, there actually is one fundamental right, is the right to move interstate. And that has been found to be, well, there's an individual right too. You know, I don't have to live in Florida. I can move. And the United States can't tell me I can't move. So there is, if you impair something about that free flow of commerce or individual right to move, there may well be a problem with that. Yes.
Councilmember Lowenthal again. One of the leaders of the Federalist Society took credit for creating a Supreme Court unassailably anti-abortion. They recruited and promoted judges before the Senate, of course, who they felt were anti-abortion. Could you comment on the role of the Federalist Society or in court?
Well, I think so the question is about did the Federal Society have an influence on the selection of judges? I think the answer is yes. That the Federal Society has been organized around sort of states' rights and more conservative viewpoints, and yeah.
The guy may have been a founder, but he was a top official. He was interviewed, and he says his lifelong goal was to create such a court that was anti-abortion, and he took credit for it.
Yeah, I've heard those things too. which is that as these cases have said, there are anti-abortion advocates who feel strongly, personally, and there are pro-choice people who feel strongly and personally. And so, yes, the anti-abortion groups and some members of these various other legal groups have sought actively for people whose judicial philosophy would fit their vision of the future. Sure.
I have a question about future of stare decisis precedents. I was listening to the hearings on affirmative action on Monday, and it seemed that everybody was talking about stare decisis, but it seems after Dobbs that they would be focusing a lot more on history and tradition, which sounds to me like sort of a bogus approach to understanding law. But nevertheless, that's what the Supreme Court went for. But
well, they are actually, they're two separable questions. One is, do you have a constitutional and fundamental right based on a right that has been part of ordered liberty, that is considered so fundamental as it must be protected, marriage, procreation, ability to raise a family, those things have been incorporated. Stare decisis is a legal procedural question. That is, what are the standards for overturning a precedent? Now, Dobbs is a good place to actually read about that, read the dissent and the majority, because they both discuss the same issues and just reach different conclusions. One of the issues is the previous precedent workable? The majority says undue burden is unworkable. Dissent says it's perfectly workable. There are a number of cases that have been implementing it, and it works. One is, the notion is reliance. Majority says there really is no reliance because getting an abortion is an unplanned act. Dissent says abortion has been part of the constitutional structure for 50 years. People have planned their lives and relationships based on that, and so reliance should be a factor. Another is changing facts. Now, I think that they discuss that in affirmative action. Now, just to mention affirmative action, when it was written and when the court affirmed it 25 years ago, I think Justice O'Connor and some others said, this is not a permanent solution, it's a remedy. So that if you evolve to a colorblind society, then you don't need affirmative action. So that's a factual evolution that you would use to overrule stare decisis. Now, just to mention a couple other cases, there is Plessy versus Ferguson was overruled. I mean, there are cases that have been overruled. Plessy versus Ferguson, separate but equal is equal. Brown says no, separate cannot be equal. So that's the Korematsu case, which was the internment of all Japanese. That was upheld by the Supreme Court and was said that, yes, it was based on race solely, but there was a compelling state interest to do it. The Supreme Court has later said it was wrong then and it's wrong now, and we clearly overrule it. So, I mean, stare decisis is an interesting area because clearly we change and things can change. But then how do you actually do the stare decisis analysis? And that's what, if you really want to focus on it, you can read the Dobbs opinion. You can see two sides of the same test, which is to say, based on these issues, you should overturn it. Based on the same issues, you shouldn't.
There's a comment in chat. You can see it there. Yes, but times have changed. People, justices are not reasonable anymore.
Okay.
I do have one question. Oh, did you have somebody else?
No, go ahead.
Okay, I do have one question that is very iffy. If it's proven that Justice Thomas's wife was involved in the preparation for January 6th, what is your feeling about the likelihood of him recusing himself?
Well, I think as we know, the justices' standard for recusal is whatever they say it is. You know, there is no appeal. It's kind of, yeah, so probably not. So I asked students, or students asked, not regarding this matter, but that's a terrible decision by the Supreme Court. What do you do about it? Well, nothing. I mean, there's nobody else to appeal to, except today we had an example. So if Dred Scott is the worst decision ever, 1857, what happened? Civil War. I mean, a 200-page opinion in Dred Scott was supposed to end the controversy. Started the Civil War, and so was Dred Scott overruled? Yes, it was. By the Civil War and the 13th, 14th, and 15th Amendments, which explicitly addressed the issues that Dred Scott found.
Any other questions or comments here in the Oak Room? Anybody on Zoom? Rick, any final thoughts?
Just to thank you so much, Professor Mills. Wonderful, provocative presentation.
Thanks. Thank you as always. Always the best crowd.